All right, so today we'll discuss on bail. So bail, have you studied contract 2? I think yes, right?
Yes.
Have you studied this contract called bailment?
Bailment studied, yeah.
Yeah, what is bailment? Do you remember?
Bailment, I remember bailment.
What is a bailment?
That bailment, this bail is not related. Is there any relation with the bailment and bail?
No.
Bailment is nothing but bailment and pledge, confusing.
Yeah. So bailment is nothing but a contract wherein you give something, right? You give your goods to another person. Maybe you are giving your clothes for ironing. That will be contract of bailment. After ironing, they would return it to you. Maybe you want to repair your phone. You would give your phone. After repairing, they would give your phone back to you, right? Those were contracts of bailment where you give something. And there used to be two parties, bailer and bailee. So this bail that we talk about, obviously bailment contract and bail, two completely different things, not related to each other. But what is related is this word bailer. Okay, it is derived from the word bailer, which means to deliver or give. In case of bailment also, there would be a bailer who would give something, like you would give your mobile phone that the display is not working, please fix it. In that case, you become the bailer, you are giving something. Okay, same ways in case of bail, what happens is you are maybe you are signing on some conditions, maybe you are putting in some surety, right? So you are the one who is maybe giving something also. Okay, maybe you would be asked to deposit your passport, some amount of money, right? All those things are there. So it's derived from this word bailer, which means to deliver or to give. The tentative release of an accused from custody is termed as bail, right? So we are tentative release. For a time frame, we are releasing the person because we are not yet sure whether this person has actually committed something wrong or not. He is just an accused person, so we are releasing him on bail. In other words, bail is the security for the accused person. Okay, so we want to ensure that this person would come back whenever there is need because of investigation. If the person is required or something, we want to ensure that he comes back, right? If today a person is arrested and he is after that released on bail, police officer wants to make sure that next time if he is required for the purpose of investigation, he will be available, he will make himself available, he will present himself before the police, right? That is nothing but bail is a security of the accused person, right? That's why the person needs to pay some money, surety would be there that he would make himself available whenever required. If we talk about Constitution, we have Article 21 under Constitution that guarantees right to life and personal liberty to individual, right? We have a right to life and personal liberty. So when we have personal liberty, then again, I mentioned in another class also that in Indian criminal system, it is unless and until you are proving a person's guilt 100%, it is assumed that he is an innocent person. Right? So if he is an innocent person, his guilt is not yet proved, he has personal liberty, why are you keeping him in a prison? Right? Why are you detaining him? Right? So that should not happen. That is why a person is assumed to be innocent unless proven guilty 100%. Hence, the accused shall not be deprived of his personal liberty unless prescribed by a fair and just procedure. After a complete trial, if his guilt is proved, his he is given punishment, then it's fine. Then you keep him in prison. But when you are only saying that he is an innocent, he would be presumed to be an innocent unless proven guilty. He has personal liberty. Why are you keeping him in prison? Right? That's the reason why we have this entire concept of bail. Okay, when we talk about CrPC, bail is mentioned under sections 436 to 450 of CrPC. Plus, when we look at first schedule of CrPC, if you remember in previous class, we have seen also, first schedule provides for a detailed list of different types of crimes which are mentioned under IPC. Plus, it mentions which section provides for that certain crime, what is the punishment for it, in which code it will be triable, is it bailable, is it cognizable, right? Do you remember that list we had seen?
List.
CrPC direct we saw, right, in first schedule.
List appeared in first schedule. I remember, madam.
Yes, right. So that is nothing but what also gives us information on what is a bailable offense and what is not bailable. Non-bailable are generally more serious crimes where person is not released on bail. Now, when we talk about different types of bails or different concepts relating to bail, there are mainly 5 different things that we need to understand. Okay, first, 2 are bailable and non-bailable offense. We have previously also discussed what is bailable and what is not bailable, but still we will see that once more today. Bail in bailable offense. So section 436 provides for release on bail of a person accused of a bailable offense. A person has committed a crime which is a bailable offense as mentioned in first schedule of CrPC, or maybe if it's not IPC but some other legislation, the legislation would ideally specifies it bailable, non-bailable. Okay, so he has committed or he is accused of committing some bailable offense and the person should be released on bail. Here, bail is mandatory in nature. Bail is like a right the person can claim, and the court or police has no discretion in this matter. Any accused person arrested for bailable offense willing to provide bail must be released. So when a person is arrested, he would be allowed to make a phone call, right, to maybe one of his relatives, friends, or family members. If family members were not the ones present and signing on the signing at the time of arrest, so he would be allowed to make a phone call so that his family members, friends, or relative can make the arrangements for the purpose of bail. So an accused person who is arrested on the accusation of committing a bailable offense and he is willing to provide the bail, he must be released. The only discretion that is available to the police is to release the accused on a personal bond or with sureties. He would be required to sign on a bond agreement like this bail bond, and he would have to sign there. There may be sureties also who would be required. So that thing police officer can decide. In cases where the accused is unable to provide bail, the police officer must produce the accused person before magistrate within 24 hours of arrest. If it happens that no one is coming for bail of the person, right, he is not able to get done with the bail procedure, police officer needs to produce him before nearest magistrate within 24 hours, like we have seen previously also. And after that, the magistrate and is willing to furnish bail, then magistrate will release. If the person is ready to furnish bail, magistrate will have to release him. There also, magistrate can decide whether on personal bail, bond, or on bond of sureties he is to be released. That part they would decide. Magistrate cannot authorize detention of a person who is willing to furnish bail with or without sureties, even for the purpose of aiding investigation, because it's a bailable offense. The person is having bail, the person can claim for it like a right. There was this case where Supreme Court held that the right to bail for bailable offenses is an absolute and indefeasible right, and no discretion can be exercised. And the person accused of an offense is bound to be released on bail once he furnishes the bail bond. Okay, there was another case wherein the court has no jurisdiction when granting bail under section 436, even to impose conditions except for demanding surety. So they cannot say that you deposit your passport, you appear every week before us. Those conditions also would not be valid in case of a bailable offense. There was another case wherein the Delhi High Court held that grant of bail to a person accused of bailable offences governed by provisions of 436 of CrPC. Bail in such a case is compulsory, and the person accused of bailable offence, if prepared to furnish bail, has a right to be released on bail, and court has no discretion. If he is ready to furnish bail, he would be released on the bail basically. Now we have mentioned, right, on his personal bond or on sureties he needs to be released. There was an amendment that took place in Criminal Procedure Amendment Act 2005, which make a mandatory provision that if the arrested person is accused of bailable offense is an indigent person and cannot furnish surety. Person is very poor and he cannot pay money for that, right? Surety amount he cannot pay. Then court shall release him on execution of a bond without sureties. Okay, so first one is bailable offense, wherein it would be like a right, a person will be released, whether he is released from the police officer or if he is not seeking bail within 24 hours, he would be produced before magistrate and magistrate will basically release the person. What about non-bailable?
Indigent, what is the meaning, madam?
Indigent as in someone who is very poor, who cannot provide this surety amount, because surety amount would be sometimes 50,000, 80,000 like that, right? So instantly, if someone is not able to pay that much money, then also he should be released. Okay, because it would happen suddenly, right? Maybe a person is arrested today and within 2 days he may need to deposit 80,000 rupees. So someone might not be having that amount also, right? So that in that case also he needs to be released. So bailable offense we have, another one is non-bailable offense, which is again very common because we have bunch of serious crimes wherein it is non-bailable offense. So in non-bailable offense, what happens is court is having a discretionary power. It is not an obligation on the courts, but court is having a discretionary power. They can take into consideration all the circumstances and everything. After that, they can take a decision whether this person can be released on bail or not. They will take a decision. And in such cases, you will see lot of bail conditions will be imposed. Have you read this Aryan Khan bail case?
Aryan Khan bail case, I remember, yeah, madam. Yes.
Sorry?
I remember Salman Khan's son's case.
Shah Rukh Khan's son. Salman Khan is not married.
Sorry.
Yeah, Shah Rukh Khan's son, right? So this was on news all over, right? Everywhere. Like, I don't think there is any person who have not heard of it, right? Everywhere on news, Aryan Khan. So he was there in custody for 25 days. After that, he was released, right? So 2 days before he was released, basically, Bombay High Court said that, okay, we are releasing the person on bail, but then we are working on the conditions, like what all conditions we should be putting in the bail bond, that we are like figuring out. After 2 days, then the final judgment came that he will be released on bail, but there were 14 conditions which were imposed. So these were some of those conditions. That he will not try to communicate with the co-accused. Like there were basically 3 three of them who were released, right? Arbaz Merchant and some other person also there. So he should not try to communicate with co-accused. He shall not leave the country without permission of NDPS court. Plus his passport was also to be surrendered before the court. He not supposed to make any statement to social media about the proceedings. He cannot leave Mumbai without informing investigating officer. He needs to give his attendance in NCB office between 11 to 2 p.m. every Friday and mark his presence. He shall attend the court on all the dates unless prevented by any sort of reasonable cause. He needs to make himself available in the court. He shall not go to NCB office as and when called. He shall go to NCB office as and when called because of the trial. If any of these are violated, then NCB can straight away apply for cancellation of bail in NDPS court also. Applicant shall surrender his passport as well, right? So these were some of the conditions imposed. Like that, there would be conditions imposed. Plus there was surety also. He had to give, I think, some 10 lakhs or something rupees.
That actress
Juhi
stood
Chawla
guarantee.
also gave, right?
5 lakhs, 5 lakhs, I think.
5, yeah, some lakhs. I forgot 5, 10, what was the amount? But yeah, that amount also had to be deposited. I actually had the case order copy somehow at some other laptop, I think. But yeah, it's available online also. You can look for that. So this is how it happened. Next is anticipatory bail. So what is anticipatory bail? Have you heard of this?
Anticipatory, right? Because suppose due to some crime situation, somebody suspects there is possibility of myself to be arrested. So anticipating that arrest, he is moving a petition before the court. That is anticipatory bail case, bail request, is it not?
Yes. Correct. So anticipatory bail is nothing but in anticipation that I may be arrested, an FIR may be filed against me, like that a person would file the case, like apply for bail. Correct. Anticipatory bail is also not defined under CrPC, but Supreme Court of India in this case has characterized anticipatory bail to mean a bail in anticipation of arrest, like you said, anticipation of arrest. When a competent court grants anticipatory bail, it issues an order that in case of an arrest, the person shall be released on bail. The person would be instantly released on bail. The protection in terms of 438 is limited, that it can be sought only till the time person is not in custody. Before arrest, he can apply for it. Once the person is arrested, he needs to apply for regular bail only. Okay, in fact, there is one recent case also on this anticipatory bail thing, that the person was like escaping from the arrest. Even though there was an arrest warrant, he was called to appear before the court also. He was like hiding all the while. After that, he filed for an anticipatory bail. Like that, there was one case where I think Supreme Court said that anticipatory bail is not valid in this case. At max, he can apply for like a regular bail. I have that case, I think on YouTube, I have that. I will put that link also here. You can go through that. That is a recent case on anticipatory bail. I guess 2021 case only.
Yes.
Okay. All right. Now, bail on default. So what is default? Very common word for you, right? In LIC, it is used, right? If
by mistake.
Yes, something you skip. Correct.
Yeah.
So bail on default. So section 167 clause 2 of CrPC empowers judicial magistrates to authorize custody of a person in case wherein investigation cannot be completed within 24 hours. Previously also we have seen that once a person is arrested, police officer would try to complete the investigation within 24 hours. But in all cases, it might not be possible. And when 24 hours is over and police officer feels that we need the person for investigation, otherwise it would be difficult, they would produce him before the magistrate, and magistrate would decide if the person can be sent for judicial custody or not. Right? So it provides for maximum period of custody that can be authorized. It further contains a mandate that if investigation is not completed within this stipulated maximum period, the accused is to be released on bail, whatever be the nature of acquisition. Right? Bail on default, as in there is default from the part of police officers that they were not able to complete the investigation within 24 hours. After that extension was given by magistrate, they are not again able to complete it. So if there is such a default, person should not be suffering for that. Person would get released on bail. So Supreme Court clarified that a person accused of an offense acquires an indefeasible right to be granted bail on meeting the bail conditions if investigation is not completed within the prescribed time frame. So if there is a default from the police officer, the accused person should not suffer. He would be released on bail. Yes, when he is being released, there may be conditions imposed that whenever you are required for the purpose of investigation, you will make yourself available, and all those conditions may be imposed, which is very much like okay, but the person will be released. Okay. Next one is interim bail. So this is a direct order by the court to provide temporary and short-term bail to the accused until his regular or anticipatory bail application is pending before court. Now, like I said in Aryan Khan's case, court said that, okay, we are working on the conditions, what needs to be put. Then after 2 days, they gave the judgment. Before that also, they heard the matter. It takes a while for the court to give a decision, right? So until the case is pending, whether a person has applied for regular or anticipatory bail, until the case is pending, court may provide interim bail to the person. Okay, as in temporarily until final order comes, we are releasing the person on bail. Sukhavan Singh versus State, the Supreme Court filled up the gap that is there between section 437 and 439, holding that the power to grant bail is inherent. The power to order interim bail, which means the court hearing a plea for regular bail has an inherent power to order interim bail pending final disposal, because it would take some time for them to consider all the relevant situations. So the person may be released on bail. That for the time frame when we are deciding, this person will be released on bail. Kanhaiya Kumar, do you remember?
I remember Gujarat, Delhi University student.
JNU University.
JNU.
Right? So much of things happened, right? 2016. He was also given this interim bail. Okay, he was granted interim bail for a period of 6 months on furnishing personal bond of 10,000 rupees and also an undertaking. So like that, it can happen. Some situations are like reported so much that these names are just there in our head. It's just 2016 incident. We are still remembering his name, right? Yes. Okay, so another one is bail after conviction. Conviction as in when full trial happened, court found the person guilty. He is convicted. After conviction, can we give bail or not? So there is just the trial court maybe, right? In the trial court, complete trial happened. Court found him guilty and court convicted him. But then the person is having the option to go for appeal, right? And many a times we have seen in appeal, the judgment is completely reversed. Court says, no, this person is not guilty, released him. Right? So even when a person is convicted, there still is, and okay, so even when a person is convicted and he has his options for appeal, review, revision, whatever relief is open, that means there still is a scope that maybe by a higher authority, like a higher court, the person may be declared as innocent, right? So that means his guilt is not yet finally proved. He also has option of going to the higher court, right? So that again brings us to the same position. If his guilt is not proved 100%, why should he be suffering in the jail? Because appeals and all take time, right? So we have this provision, that is bail after conviction. So a situation where convicted person can get a bail from appellate court after filing the criminal appeal, as in he has opted for the appeal and decision is yet to come. Section 389 deals with a situation where trial court itself can grant a bail to convicted accused, enabling him to prefer an appeal. Court may say that this is what the punishment we are giving, but then the person is having right to file an appeal maybe within 90 days, 60 days, 30 days, whatever. So until this period, person should not be arrested, because let him file the appeal if he is willing to, right? Like that also it might happen that, yes, this is the sentence what we are giving, but it would be imposed only once this duration to file appeal has expired. Like, let him take all the benefits that are being given to him. There was a case, Atul Tripathi versus State of UP. It was discussed, Supreme Court discussed the scope and ambit of this provision, bail after conviction, and issued some guidelines. So the appellant court, if inclined to consider release of a convict sentenced to prison or for death, imprisonment for life, or like a higher punishment basically, shall first give opportunity to the public prosecutor to show cause in writing against such release. So there would be one government side lawyer, right? We see, right, state versus so-and-so. So whoever was representing state, like the public prosecutor, we have seen, right, functionaries under CRPC, public prosecutor, right? So appellate court would ask this public prosecutor, because you dealt with this case for all this while, give us reasons, if you have any, on why you think that this person should not be released, maybe, right? Show cause against the release. If you have any points, you can mention that maybe there were situations wherein the accused person tried to threaten victims or witnesses, tried to tamper with evidences. If you have any grounds, you tell us that. Otherwise, we may release him on bail. On such opportunity being given, the state is required to file its objections, if any, in writing. It would ideally be state versus so-and-so. So on behalf of state, some objections may be raised that this is what had happened previously, so we object releasing the person on bail. Like that, it can be done. In case the public prosecutor does not file the objections in writing, the appellant court shall, in its order, specify that no objection has been filed despite the opportunity given. We asked for objections. Nobody raised any objections as well, right? That is what the appellate court would say. Next one is that the court shall judiciously consider all the relevant factors, whether specified in objections or not, like gravity of the offense, nature of the crime, age, criminal antecedents of the convict. Is he a person who is committing crimes after crimes? Impact on public confidence in court. If he is released, is it that public's confidence on court would be shaken? Because there are some cases, right, where it's obvious, everyone knows about it, and if such a person is released, people would be like, why or how come? Right? So those questions would be considered by the court. Take, for example, if Ajmal Kasab, just assume if Ajmal Kasab was released on bail, that his appeal was pending, everyone would question, right, that how come he is released on bail, right? So those sort of situation, court to take care of everything, because every case is different from the other. So considering all those things, court will take a decision whether it can be granted or not. Okay, so these are the 5 different things that we need to understand. Bailable offense, you have a right to ask for bail. Non-bailable offense, discretion of court. Court may impose conditions also. For conditions, again, court is free to look into the conditions, what can be imposed, what cannot be imposed. There was another very famous case of 2021, wherein what happened, right? I think it was some case of it was a case of rape or sexual assault, something, and the person was released on bail by Sessions Court or High Court on the ground that you need to go to the this witness, the victim, right? You need to go to victim's house with your wife, and you need to ask the victim to tie a rakhi. Okay, as in you are like brother. Ask her to tie a rakhi, and after that take care of her like a brother. That was like a condition which was imposed in bail bond. Okay, so that was again challenged before, I guess, Supreme Court, and then Supreme Court said that this cannot be like a ground or a condition of bail, right? Because in criminal law we want to keep the accused person as away as possible from the victim, because victim has already suffered. And in such kind of a crime, if you are asking that you go to the victim's house, ask her to tie a rakhi, that is like completely irrelevant kind of a condition. So there court said that no, we are cancelling this thing. This would not happen. I'll give you the case also. I have it somewhere written.
High Court suggested to meet the victim with the wife.
I'm not quite sure whether it was High Court or Sessions Court, but yeah, some court between these two only. High Court or Sessions Court had suggested if you want bail, you go along with your wife, you go ask the victim to tie a rakhi, and just like a brother, you take care of her, like that it was said. And then that was challenged before, I guess, Supreme Court. Supreme Court said that it should not happen, and High Court or Sessions, whatever it was, should be a little sensitive on this matter, like that decision came. I guess it was also 2021 case only. So yeah, anticipatory bail, in anticipation it would be granted. At interim bail, it would be
after conviction.
Yeah, for the time being when the case is pending. Bail after conviction, once it is decided, and bail on default. If there is default from the police officer, they are failing to complete the investigation on time again and again, there also it may be granted. Okay, is this part clear?
Clear, madam.